and welcome to the Estate Agents Affairs Board Continuing Professional Development Session. My name is Tiaan van der Berg and I'm a director at MC van der Berg Attorneys. We are an attorney firm specializing in property law situated in Pretoria. Today I want to talk to you about what I perceive as the 10 deadly sins that estate agents make. Now, the one thing that you need to know about sin is the following. The first thing is that sin might result in death. That means that your contract will be void. It might also mean that your contract can be alive, but it can become voidable. You can also land up with a civil claim against you. You can be embarrassed in the market that you work. You can get a bad name in the market. And ultimately, you might even cut commission, which you don't want to do. You can land up with a complaint at the EAAB. And obviously, it can waste a lot of your time and create a lot of frustration for you. Some sins I have seen are personal in nature, and unfortunately there's nothing that I can do about that. Some sins, unfortunately, are inherited in your pro forma agreements. Some are organized by the parties to your agreement, some are habitual, some exist purely because you don't apply your mind, and some is unfortunately a result of you as the agent trying to do the conveyance's work. But all sins can be avoided. One, by acquiring the necessary knowledge. Two, by using a properly drafted pro forma agreement of sale. Number three, by applying your mind. And four, using a conveyancer that you can really rely on and who will do his work. The first sin that I want to discuss with you is the fact that a lot of estate agents misunderstand the various matrimonial property systems in South Africa. In South Africa, you are either married in terms of the Marriage Act, the Civil Union Act, the Recognition of Customary Marriages Act, or Muslim and Hindu rights, or another country's laws. Now, the reason why this is important is depending on in which terms of which act and rules you are married, there are various matrimonial property systems that can apply. If you are married in terms of the Marriage Act, which I will explain to you right now, or the Civil Union Act, or in certain cases, if you are married in terms of Muslim rights, the Matrimonial Property Act will regulate your matrimonial property system. It might also be that the Customary Marriages Act regulates your matrimonial property system, and in certain other cases, if you are married in terms of Muslim or Hindu rights, a different set of rules will apply. And then lastly, it might even be that another country like England or Nigeria's laws dictate your matrimonial property system. In terms of the Matrimonial Property Act, you are either married in community of property or you are married out of community of property. The default setting in terms of the Matrimonial Property Act is that you are married in community of property. That will mean that if you get married and you don't have an antenuptial contract, you will automatically be married in community of property. If you want to change that dispensation and you want to be married out of community of property, you have to enter into a prenuptial contract with your spouse before you get married. Now, in terms of the Matrimonial Property Act, when you are married out of community of property, it can either be with the accrual system or without the accrual system. But the accrual system is a system that is only applicable to the matrimonial property system once the marriage is dissolved. That means when the parties get divorced or either of the parties die. So for the purposes of being an estate agent, you should never be concerned whether a person is married with or without the accrual system, only whether they are married in community or out of community of property. If you are married in community of property, it means that there is only one estate. Either the husband or the wife can't purchase or sell property on their own. When they purchase property, they will co-own the property 50-50% in undivided shares. Undivided shares means exactly what it says, is that you can't split the property in half and the one spouse can sell off their half shares. It is undivided. You don't know which portion of the property is yours and which portion of the property is not yours. What is important for an estate agent is to remember that when either their purchaser or their sellers are married in community of property, because there's only one estate, both the spouses have to sign the sales agreement in their capacity as purchasers or sellers, otherwise the contract will be void. If the spouses are married out of community of property, it means that there are two estates. The one spouse, let's say as an example the husband, will have his estate and the wife will have her estate, which now means that either of the parties can purchase or sell property without the consent of the other spouse. It also means that if they do own a property together, that they do so in divided shares, which means that either of the spouses can actually sell off their half share to a third party without the consent of their spouse. In the beginning I said that in South Africa you are either married in terms of one of 5 ways. Now let's look at the Marriage Act. The Marriage Act is the oldest act in South Africa that regulates marriages. If you are married in terms of the Marriage Act, you have a so-called civil marriage. Your matrimonial property system is then regulated by the Matrimonial Property Act. That means that by default you are married in community of property, but if you do have an antenuptial contract, you will be married out of community of property. The second way that you can get married in South Africa is in terms of the Civil Union Act. The Civil Union Act is to a certain extent a copy of the Marriage Act, but it makes provision for people of same sexes that wants to get married. You will also have a civil marriage, and like in the case of the Marriage Act, the Matrimonial Property Act will also be applicable. That means that if a husband marries another husband, their default setting will be that they are married in community of property unless they entered into an antenuptial contract, which will then mean that they are married out of community of property. Where it becomes a little bit more difficult is with the recognition of customary marriages, which is the third way that you can get married in South Africa. Now, when black people in South Africa get married in terms of customary law or lobola, in the past the position was a little bit unclear. But on the 15th of November in the year 2000, the Recognition of Customary Marriages Act was promulgated, and that act now regulates the position. There were a number of court cases that interpreted this specific act, and the rules pertaining to customary marriages are therefore the following. If you are married in terms of the customary law before the 15th of November 2000, you are deemed to be married in community of property. If you are married after the 15th of November 2000, your matrimonial property system will be regulated by the Matrimonial Property Act, which means that if you don't have an antenuptial contract, you will be married in community of property, and if you do have an antenuptial contract, you will be married out of community of property. Where it becomes even more difficult is with Muslim and Hindu rights. For many years in South Africa, people married in terms of Muslim rights were regarded as not married. But since the 1st of May 2014, the position has changed. With Muslim marriages are as follows. Before the 1st of May 2014, the South African law did not recognize Muslim marriages. That means that if a Muslim couple is married before the 1st of May 2014, their marriage would not be regarded as a civil marriage. The spouses could therefore act independently and purchase and sell property without the consent of the other spouse. If, however, this Muslim couple is married after the 1st of May 2014, there's a different set of rules that will apply. On the 1st of May 2014, it was decided that if the person who officiates the marriage is registered in terms of the Marriage Act, that marriage will be regarded as a civil marriage. So if a Muslim couple comes and they get married after the 1st of May 2014 before an imam, and the imam is not registered in terms of the Marriage Act, that marriage will still be regarded not as a civil marriage, exactly the same as if they were married before the 1st of May 2014. If, however, on the 1st of May 2014 or thereafter, they get married in terms of Muslim rights, and the imam is a registered person in terms of the Marriage Act, we recognize that marriage as a civil marriage, which will then mean that the marriage dispensation, the matrimonial dispensation, will be regulated by the Matrimonial Property Act. Therefore, if this Muslim couple doesn't have an antenuptial contract, they will be married in community of property, and if they do have an antenuptial contract, they will be married out of community of property. Unfortunately, this position hasn't changed with Hindu rights. If people are married in terms of Hindu marriages, we still regard them as not married, and therefore various spouses, the two spouses, can contract independently. The fifth way that you can get married in South Africa is in terms of another country's laws. Or it might even be that you didn't get married in South Africa, but that you got married in England, for instance. Now, it's very important to remember that it's not the place where you get married which dictates which country's laws will be applicable to a specific matrimonial property system, but rather where the husband is domiciled. Unfortunately, currently where we stand, we don't know what is going to happen in the case where we have same-sex marriages, because that hasn't been regulated by any legislation or any court case. If you are married in terms of a foreign country's laws, the following rules will apply. If a French gentleman comes down to South Africa for a holiday, for instance, and he sees a lovely little townhouse for 300 million rand that he wants to buy in Clifton, he can enter into an agreement as long as he purchases that property for cash. But the moment that that French gentleman wants to sell the property, or he wants to encumber it with a bond, he is going to have a problem, because in terms of our laws, he will then need the consent of his spouse. The next sin that I want to speak to you about is representation. Remember that in our law, we have various persons. We have natural persons, human beings, people like me and people like you, but we also have companies and closed corporations, which for the purpose hereof we will call juristic persons or legal entities. And then we also have trusts or other entities like churches and clubs, which we will call quasi-juristic persons for the purposes hereof. Now remember that when a natural person, a human being, enters into a contract, they have arms, which means that they can sign the contract themselves. But in the case of a juristic person or a quasi-juristic person, that entity only exists on paper, which means that they can't sign it themselves, and therefore they must be represented by a human being to do it on their behalf. The juristic person or the quasi-juristic person will be bound by the agreement, but it is important that the signatory, the person who signs on behalf of that paper person, is indeed duly authorized to sign that documentation. As an estate agent, you can't simply assume that all directors of a company, all members of a closed corporation, all employees of a company or a closed corporation, any official, any trustee, or even the priest of a church has the authorization to sign an agreement where you sell or purchase land. Therefore, you need to obtain a resolution. A resolution is a one-page document where a decision is taken by the legal entity to purchase or to sell property at a specific price to a specific person, and that a specific human being can represent that juristic person or quasi-juristic person. It's very important that we actually hold that representative liable in our contracts, because it might be that that person who says that he is authorized is indeed not authorized to act on behalf of that juristic or quasi-juristic persons. Now let's look at a few examples. In the case of companies, remember, companies are regulated by the Companies Act in South Africa. If we have a company, let's say for instance the company's name is Snapshot Pty Ltd, and we have a registration number 199901235/07, and this company is represented by Johannes Koopman, then in your purchase agreement you have to make provision for the company's name. The company's name with a registration number, and it must then clearly state that this company is represented by Albert Koopman in this case. It is very important that your contract must place the responsibility for certain things on the signatory. There are certain things that you as an estate agent will simply not know. Number one, that the signatory is indeed authorized. Number two, that he is duly authorized. And when it comes to duly authorization, we actually refer to two things. Number one, internal compliance, and secondly, external compliance. We need to know that the person who has been authorized has been duly authorized in terms of the memorandum of incorporation, or if the party, either of the parties is a trust in terms of the trust deed, or if either of the parties is a closed corporation in terms of the cooperation agreement, or if it is a different entity like a church or a sports club or a pigeon club in terms of the constitution of that specific club. But it's also important that the signatory certifies that he has complied with all external factors like the Trust Property Control Act, the Companies Act, and the Close Corporations Act. What is important for you as estate agents to remember is that you have to apply your mind when it comes to the signing of these resolutions. Because in the case of a company and a close corporation, the resolution can either be signed before the signatory signs the agreement, or it can be signed after the signatory signs the agreement, in which case it will be called a ratification. But unfortunately, the Trust Property Control Act, which regulates trusts, does not make provision for ratification. In the case of a trust, it is important to remember that the Trust Property Control Act does not make provision for the ratification of a transaction after the signatory signed the agreement. This principle was also reiterated in the Supreme Court of Appeal case in Erroneous versus Investec, where the courts said that if the resolution in the case of a trust, regardless whether the trust is a seller or a purchaser, is signed after the agreement, the contract is null and void. A very important aspect that agents must also remember is the aspect pertaining to pre-incorporation agreements. Now, we have a common law principle, a principle that derives from the Roman Dutch law that says that you cannot act as a representative for something that doesn't exist. That is the common law principle. Now, in the case of companies and close corporations, the Companies Act and the Close Corporations Act changed that common law principle. Therefore, in the case of a company, you can enter into a contract for a company to be registered. It used to be that way in the case of close corporations, but the Close Corporations Act now says that you can't register new close corporations. Therefore, you cannot enter into an agreement for a close corporation to be registered. But in the case of trusts, the Trust Property Control Act does not make provision for pre-incorporation agreements. Therefore, in the case of trusts, the common law principle still stands, which is that you can't act for a trust to be registered. Any contract that is entered into for a trust to be registered will be void. In the case where a purchaser entered into an agreement for a company to be formed, the following will have to happen. And you will have to regulate this very clearly in your agreement. The company will then have, or the signatory will then have, a specific time period within which the company has to be registered. And once the company is registered, that company will have a certain time period within which they have to ratify the agreement. It's very important that in a case like that, where you make use of a pre-incorporation agreement, that you hold the signatory liable, that if the company is not registered, or if the company does not ratify the agreement, that we can hold the signatory responsible for any damages and possibly for your commission. The third sin is the uncertainty that estate agents have about transfer duty and VAT. So often estate agents phone me, or I can see in their contracts that they are not certain whether there is transfer duty applicable on the transaction or whether there is VAT applicable on the transaction. And the principle is actually quite easy. You must start off to remember that they are in conflict with each other. It can never be transfer duty and VAT on the transaction. It's always either transfer duty or VAT. So you can see the two boxes there are in conflict and they will never hug each other. You will never have transfer duty as well as VAT on your transaction. Now people, it's quite easy to understand the principle. Just think, when you walk to the spa, your local spa, and you buy a bottle of Coke, is there VAT on the Coke? Yes, there is VAT on the Coke. When you come to the till, does the lady behind the till ask you whether you are registered for VAT before she charges you VAT? No. And the reason therefore is quite simple, and that is that VAT has got nothing to do with the purchaser. VAT has got everything to do with the fact that SPA is a registered VAT vendor. So whenever, and it works exactly the same with a property deal. So when we work with a property deal, you have to start and you have to ask your seller two questions. Because remember, whether your purchaser is registered for VAT is not really applicable when it comes to the transaction. It might be that because the purchaser is registered for VAT, he can claim the VAT back from SARS. But we have to start off and we have to ask the seller two questions. Number one, Mr. or Mrs. Seller, are you registered for VAT? If the answer on that is no, It's impossible that there is VAT on the transaction. You have to look at the Transfer Duty Act. You have to say, okay, if there's no VAT on the transaction, what is the purchase price? And then apply the schedule and the rates as announced by the Minister of Finance. If the seller, however, says to you, yes, I am registered for VAT, you have to ask a second question, and that is the sale a VAT supply? Remember, when Spar sells Coke, the Coke is part of their supply. But let's say you have a lawyer, and the lawyer is registered for VAT in his personal capacity. Let's say, for instance, me as example. I'm a lawyer, and I'm registered for VAT in my personal capacity. When I sell the house that I live in, although I am registered for VAT, there will be no VAT on the transaction, because the house that I'm selling is not a VAT supply. So if you look at that slide, two questions. Number one, are you registered for VAT, Mr. Seller? Is this a VAT supply? If both those questions are positive, then the VAT Act is applicable, and then you have to look very carefully at your contract, whether VAT is inclusive or whether VAT is exclusive. In so many instances, a developer who is registered for VAT, who is selling that property, which means it's a VAT supply, will tell you that he wants R1 million for the property. You then sell the property for R1 million, and afterwards he turns around and he says what he meant is that he wants R1 million in his pocket, and you still had to add the VAT. So make very sure that when it is a VATable transaction, whether the VAT is inclusive or whether the VAT is excluded in the transaction. If either of those questions or both those questions are negative, then you will look at the Transfer Duty Act and you will say, good, let's pay transfer duty. The purchaser has to pay the transfer duty. I think it's very important, because I know that it's very difficult for you as an estate agent to know exactly what the position is. I think it's important that in your pro forma agreement you make provision for a clause where the seller confirms whether he's registered for VAT and whether it is a VAT transaction or not. The next sin that I see that estate agents commit is that they get confused between the sources of the funds. People remember that once you've given the contract to the conveyancer must execute that agreement. And in many instances, when we read the contract, we simply don't know where the money is coming from. Make provision in your contract to clearly indicate where the money is coming from. And there is really only four sources. It is either a deposit, or the money is coming from a bank loan, or the money is coming from an investment, or it is coming from a subject to transaction. Don't get these confused. So often I see that when a purchaser says to you that he's getting money from a transaction that he's selling, and that transaction is going to register within the next day or two, you then enter that money as a deposit into your contract. It can never be a deposit, because something can still go wrong in that transaction. So you have to talk to your clients and to your purchasers and make very certain where is the money really coming from. In many instances, when it comes to the sources of the funds, we see that you enter into your contract, as example, that the purchaser will pay the deposit within 7 days. When we get the contract and we want to execute the contract, and after 7 days want to get the deposit, the purchaser then tells us, no, but it's on a fixed term investment and he can only pay it within 30 days, which then makes it very difficult for us, because we have to execute the agreement. We have to go back to the seller and say, but this is not a deposit payable within 7 days. It's actually money coming from an investment. So please make sure that you know exactly where the money comes from. Make provision in your contract so that everybody knows exactly what is going on in the transaction. The next sin that estate agents commit is not addressing the issue of fittings and fixtures correctly. We have to differentiate between what fixtures are and what fittings are. Fixtures, by definition, forms part of the property, and when you sell the property, it remains on the property and the seller cannot take it with him. Fittings, on the other hand, does not form part of the property, and when the seller moves, they can take it with them. Certain things are clearly fixtures and certain things are clearly fittings. For instance, garage door motors are fixtures. I can hardly see that a person can argue that a garage door motor is a fitting and that they can take it with them when they move. Things like a creepy crawly is a fixture. It forms a unit with a property. A remote, lights, bathroom rails, a swimming pool, trellis doors, those are all fixtures. Clearly fixtures. Mirrors, curtains, furniture, pot plants, those are all fittings. But what about a DSTV dish? What about a TV antenna? What about a blind? If I ask you today, a blind in a house, is it a fixture or a fitting? If you take longer than 1 second to think, you must know that your purchasers and your sellers are going to differ about it. And I promise you that I can make out an argument equally, whether it's a fixture or whether it's a fitting. What you have to do is to regulate the position in your contract. What about things like pelmets? Are all mirrors really fittings? What if a mirror is cut and it fits exactly into an arch in a house? Is it a fixture or a fitting? Once again, clients differ. We get examples where microwaves, which we will all automatically think is a fitting, where a microwave fits exactly into a hole in the kitchen cupboards. And people make out the argument and they say, but this is a fixture, it goes with the kitchen. I've heard that people say that the rule that you have to apply is that when you take the house and you turn it upside down, everything that falls off are fittings and everything that sticks to the property are fixtures. That is not true at all. The courts in the past have guided us to a certain extent, and the questions that the courts ask are the following. What was the intention of the party who fixed that specific item to the property? How is it attached? What is the way of attachment? Will there be damage to the property if it is removed? And very important, does it form a unit with the property? I think the fourth item is most probably the most important one. If it forms a unit with the property, it goes with the property. Let's take as an example a pool net that is cut to the form of a pool. Surely when you turn the property upside down, that net might fall off. But the point is, it goes with the property. It is cut for the property. Therefore, it will be deemed as a fixture. Because an argument can be made out whether a specific item is either a fixture or a fitting, is I beg of you, what you must do is when you list the property, is ask the questions. Ask about the blinds, ask about the lights, ask about the chandeliers, ask about everything and enter it into your agreement. In so many instances, I've seen that this issue about fixtures and fittings ends up in a boardroom where the estate agent says, I will pay for the blinds, I will pay for the creepy crawly, and they cut their commission just to ensure that the transaction goes through. Rather spend the extra 20 or 30 minutes and apply your minds and deal with the matter beforehand correctly in your agreement. The next sin is suspensive conditions. We typically get 2 suspensive conditions in a standard pro forma estate agent's agreement. One is for a bond and one is for a subject to transaction. I'm going to deal with bonds in sin 6.1 and subject to transactions in sin 6.2. Now the question that I want to ask is, I can see that a lot of estate agents don't really understand exactly when is a suspensive condition fulfilled and when it is not. So I want to ask the question, when will a suspensive condition be fulfilled? And the answer is when it is met in full and in time. You must see a suspensive condition as a guillotine. Now in that little hole in the guillotine is the head of your contract. The blade is the suspensive condition. If the suspensive condition says that your client must get a bond by the 31st of December 2016, 12 o'clock that night, that blade is going to fall and it's going to chop your contract's head off. You can't resuscitate the agreement afterwards with an addendum. You can't fix it. It is dead. So whatever you are going to do to save your transaction the morning of the 30th of December, you have to do before the blade falls. You have to enter into an addendum to shift that date to a later date. Sin 6.2 deals with subject to transactions. Now once again, exactly as in the case of a bond, we have a guillotine and your contract's head is in the hole in that guillotine. If you sell a property, subject to the sale of the purchaser's property somewhere in Paternoster, it means that your contract is suspended till that transaction in Paternoster is completed. Now the question is, when will the transaction in Paternoster be completed? Not when a deal is signed in Paternoster, but when the suspensive condition in that agreement is fulfilled duly and in time. So therefore, it's very important that when you deal with subject to transactions, that you keep a close watch, or you must get your conveyancer to keep a close watch on the paternoster transaction to ensure that the suspensive conditions in that contract is fulfilled before the due date in your agreement. Sin 7 is the question about existing lease agreements on the property that you sold together with the huur gaat verkoop principle. Now, when you list a property, obviously one of the questions that you have to ask is whether the seller is staying in the property or whether there's a tenant in the property. And the moment the seller says to you that there's a tenant in the property, all the red lights must go on for you, because then we have to deal with that position in detail. So when you conclude a sale agreement, determine if the property is currently under a lease agreement. If so, obtain a copy of the lease agreement. You have to forward that lease agreement to the conveyancer. The conveyancer and yourself must establish the following. Is it a valid lease agreement? Is there a period of lease in that agreement? Is there a notice period in that agreement? When will the lease agreement terminate? Is there a letting agent involved? Because certainly if there's a letting agent involved, we have to pull that person in again. And then we have to deal with the position of the tenant. And the reason why this is so important is that in our common law, in the Roman Dutch law, there's a principle, huur gaat verkoop. That principle purely means that a rental agreement signed before a purchase agreement is stronger than the purchase agreement if it is a short-term lease. This is not applicable to long-term leases over 10 years. So if we look at this picture here, we have a landlord who is leasing a property to a tenant. The landlord then sells his property to a purchaser. And now the question is, which one is stronger? And the huur gaat verkoop rule says that that purchaser must now honor the rental agreement with the tenant. And this is very dangerous, because this means that if you sell a property with a tenant in and your conveyancer transfer that property to the purchaser, that purchaser might be stuck with that tenant till the end of that lease agreement. To protect yourself, I think that it is wise that in your purchase agreement you enter a clause where your seller confirms what the position is. Like in this case, we have a clause that says tenant occupying the property. The seller confirms that the property is not leased to a tenant on date of signature of this agreement, or option B, the seller confirms that the property is leased to a tenant on date of signature of this agreement, and that the situation is accordingly regulated. And in this case, what I've done is added an annexure to the agreement, and you will see why this is important right now. And then I will get the seller to initial right next to it so that we can make sure that his attention has been drawn to this position. Remember that if a property is rented to a tenant, your purchaser is on risk as a result of the huur gaat verkoop rule. There is only one of 3 ways to deal with this situation. Number 1 is that the lease agreement is ceded to the purchaser. So the first option that you have is simply that the property is transferred from the seller to the purchaser, the tenant remains in the property, and the tenant then becomes the tenant of the purchaser, and the purchaser becomes the landlord in the place of the seller. This is the easiest option. The second option is where you delay the transfer till the termination of the lease agreement. We will then have to make sure, when does the lease agreement terminate? And if so, we have to make sure that all the due notices in terms of that termination, in terms of the agreement as well as in terms of Section 14 of the Consumer Protection Act, is given to that tenant of the impending termination date. It might also be, the third option, that the tenant is willing to expedite the termination of the lease. And there you must be very, very careful, because remember that if the tenant says they will terminate the lease agreement earlier, it might be, and most probably will be, that that lease agreement is in writing, and that lease agreement has a so-called non-variation clause, which says that the early termination of that agreement between the landlord and the tenant has to be placed on record in an addendum, and that both the parties have to sign. Don't accept the tenant's verbal confirmation that he will move out on an earlier date as it is said in the contract, because you will burn your fingers at the end of the day. The 8th sin is disregarding the seriousness of occupation. I don't think that there is a more serious and possibly severe point in a transaction than when the purchaser moves into the property before registration. Personally, I believe that the best day for occupation is registration, but practically that doesn't always work. So in many instances, we have to have an occupation date before date of registration. So often I see that estate agents' contracts make provision for a lot of legalities, but they forget about all the practicalities. The contract that we have drafted in our firm, MC van der Berg Attorneys, actually makes provision for certain things that needs to be in place before a purchaser can move into a property. If you like this, please use this. I think it is important that the conveyancer must confirm to the seller and the purchaser and the estate agent that the following is in place. Number one, obviously that the occupational rent is paid and that it is cleared by the conveyancer's bank. Together with that, we must remember that most municipalities these days don't allow purchasers that occupy property to open the utility accounts into their name before date of registration, this as a result of the Mitchell, Mkuntwana and Matabate cases. Therefore, when you enter the occupational rent into your contract, you also have to make provision for an estimated amount for the utilities, because the purchaser is now going to stay in the property, use the water and the electricity, but he can't put the utility bill onto his name, which means that the seller is going to become liable for it if you haven't collected money for it. The second thing that is very important is that the conveyancer have to verify that all the deposits are paid. We don't want a purchaser to occupy a property before registration and he hasn't paid all his deposits. He hasn't delivered all his guarantees. It's also very important that the conveyancer, the transferring attorney, confirms to the seller and the purchaser and the estate agent that all the costs are paid. But surely in the world that we live now, for some reason that I don't understand, banks don't want to give the bond to the transferring attorney, which now means we have two sets of attorneys. We have an attorney dealing with the transfer, we have an attorney dealing with the bond. Surely the transferring attorney must take the responsibility upon him to ensure that not only his costs are paid, but that also the bond attorney's costs are paid before he gives the okay that the purchaser can move into the property. It's the same with documentation that has been signed. It's senseless for a transferring attorney to confirm to the seller that his documentation has been signed. The purchaser moves into the property, then the transaction can't register because the bond attorney's documents haven't been signed. Remember that the bond attorney has no relationship with the seller. The bond attorney is not going to notify the seller that his documentation hasn't been signed or that his costs haven't been signed. It is the transferring attorney that has been appointed by you or by the seller that must confirm whether the bond attorney's costs are paid, whether all his documentation has been signed. And the next point, equally important, it is the transferring attorney that must establish whether his and the bond attorney, if they have received all the documentation in terms of the Deeds Registries Act, in terms of FICA, or in terms of their SLA with the banks. We can't find ourselves into a position where the purchaser moved into the property, the seller has packed up and moved down to Paternoster, and then we find out that we can't register the transaction because none of these are done. Very important, people, is to remember that SARS will not issue a transfer duty receipt if either of the parties' tax affairs are not in order. Now let's say, for instance, that your purchaser owes SARS 20 million rand. You get your purchaser to sign all the documentation, he pays all the costs, he pays the occupational rent, he moves into the property on the Saturday, and the Monday morning your transferring attorney e-files the transfer duty documents to SARS, and SARS turns around and they say, you must be crazy, this purchaser owes us 20 million rand. Then you have unsettled a seller, he's moved out of the property, he's bought another property somewhere else, committed himself on that side. We can't register the transaction because the purchaser owes SARS 20 million rand. I think it's imperative that you make it a contractual condition that your conveyancer e-files the documentation at SARS, so that when he gives, the transferring attorney gives the okay to the seller and say, sir, you can move out, all of those things are in place and the seller is not at risk at all. The second last sin, sin 9, is all about the misinterpretation of the ambit of the Consumer Protection Act. The purpose of the Consumer Protection Act is, amongst other, to promote and advance the social and economic welfare of consumers. It is there to promote fair business practice. It is there to protect consumers. It is there to promote consumer confidence and empower them. A lot of people in South Africa, for some bizarre reason, think that the Consumer Protection Act is a blanket act that you throw over all transactions in South Africa, while this is not the case. The ambit of this act is actually limited. If you look at the definitions of the Consumer Protection Act, it clearly says that the Act, the Consumer Protection Act, is only applicable to certain transactions. It defines a consumer as somebody who enters into a transaction with a supplier. And then, very important, it defines a supplier as someone who delivers a product or a service. So it's either a house, like the seller, or a service, like you as an estate agent, in the normal course of their business to this consumer. This means, people, that the aim of the Consumer Protection Act is to regulate the relationship between suppliers and consumers. As an example, it's there to protect you and me when we go and buy a fridge from Macro, because Macro is a big company, it's got a lot of muscle, and you and me are poor people. We go to Macro, we want to buy a fridge, and we can't arm wrestle with Macro. Therefore, in terms of the Consumer Protection Act, we have certain rights as consumers. The purpose of the Consumer Protection Act was never to regulate the position where the old lady down the street sells her property to a young IT specialist, because the old lady down the street is not a supplier of houses. She does not supply property in the normal course of her business. Therefore, because she's not a supplier, the young IT specialist who is now purchasing his first property cannot be a consumer. And if that person is not a consumer, the Consumer Protection Act, with all the rights contained in it, cannot be applicable in the relationship between the seller and the purchaser. But remember, the Act is always applicable in the relationship between you as an estate agent and your purchaser, as well as your seller. Because as an estate agent, you are somebody who is